Okay, we're officially going to get started now. So the next session is State of Litigation, Data Breach, and Coverage Litigation Update. The moderator for this session is Tim Francis. Tim is a past speaker and co-chair of this event. It's always great to work with Tim. And Tim, thanks for coming back this time and running this panel. He's second vice president for Travelers Bond and Financial Products. It says Mr. Francis here, but can I call you Tim? Lead Travelers Business Insurance Management Professional Liability Initiatives. He also serves as the enterprise lead for cyber insurance. So I'll turn it over to Tim. Thank you.
Thanks very much. So let me do some quick intros. So to my right, Chandler Gibbons is an associate at Edelson PC, where his practice focuses on technology and privacy class actions. Ron Rather, to his right, works at Ruki, Ireland, and Cox. And Mr. Rather has a broad experience in technology-related issues and brings important perspective to successfully resolving disputes and developing creative compliance programs. Sorry, we're good. Tanya Forshay is partner at Baker Hostetler and works with clients to address legal requirements and best practices for protection of customer employee information. And last but not least is Tim Blood, who's managing partner at Blood, Hurst & O'Riordan, and his practice focuses on complex litigation, including class action litigation, since the early 1990s. So with that, this is the panel that I sometimes refer to as kind of the why panel, right? So we have all the other panels that have already happened and that will happen, and we'll talk about things about what our best practices and what companies need to do either to avoid a data breach, what they need to do to handle it most appropriately. If we look at the court cases, we look at litigation, we'll start to understand better why do we need to do those things, why do our customers need to do those things. So let me tee it up this way if we didn't already get to it. So show of hands, who's on the plaintiff side? And who's on the defense side? All right, so my role is to say, no eye gouging, no hitting below the bell, let's have a clean, fair fight. So let's do it this way. Ron, why don't we talk a little bit about either recent or important court decisions that affect the data breach environment today and where we are today.
So on data breach, we've really been dealing with it since 2005. And in 2005, the initial hurdle for plaintiffs was standing. And if you had asked me 2 years ago if standing would still be an issue for plaintiffs' counsel, I would have told you, and I probably did tell you in one of these events, no. That when you looked at the case law and you looked at the trends, that their creativity and tenacity was beginning to address the standing issue. We had other hurdles that we had put up, but we still had that one. Or we didn't have that one any longer. Then the Supreme Court came along and they gave us a decision called Clapper. And if you don't know standing basically requires a concrete, traceable injury that can be redressed. That's a very simple way of talking about standing. And Clapper came along, and so we started seeing challenges to standing again. And we had two important cases, I think important cases, in the last 45 days. So the Neiman Marcus and the Adobe cases, and I highlight those because they came to different conclusions. So while in the Neiman Marcus case, the court found that the risk of potential future harm of identity theft, that the plaintiff going out and buying their own services was not sufficient to establish standing. The court said under Clapper, there is no standing. With Adobe, under a lot of the same facts, the court in the Northern District of California came to a different conclusion and found that Clapper didn't really change Krotner, which was a decision, Krotner v. Starbucks, a decision out of the Ninth Circuit, didn't really change that, and I'm going to continue to find standing. All of that is, I think, symptomatic of what we've been talking about for years. I've been doing privacy litigation for almost 20 years now in different statutory schemes, and what you see is courts watching cases come before them over and over, initially finding a technical reason to get rid of those cases, plaintiff's counsel being creative and finding a workaround to that. Supreme Court comes in, gives us an additional argument. My point being that there's a little bit of hope, but don't think that the issue has gone away, and I'm sure You'll talk more about that. The other two things, real quickly, one is on damages. So we've talked about AvMed. That's a decision out of Florida, went up to the 11th Circuit, found damages on just enrichment claims because plaintiffs in the class were required to pay $30 and I think $10 of that, or some portion of that, went to data security. The court found that when the breach occurred, the promises through the contracts and the warranties weren't upheld. The reason why I raise that is because there's been two recent decisions out of California that go a different direction with that same issue. The Sutter Home and the UCLA Health decisions in the HIPAA context. So, we have the standing hurdle, we have the damage hurdle, but ultimately we're all still settling, and there's some interesting decisions out there on the settlement side. The StubHub settlement, where parties came to an agreement, $2 million. There was a claim process. If any of you have done a class action settlement, court looked at the number of claims that were approved, or a number of people that made claims against the settlement, found that didn't seem to provide sufficient consideration, refused to provide final approval of the class, given the disproportion in the claims and the attorney's fees, asked the parties to go back and work it out some more. And then Schnucks, which is another one of those cases where the court was proactive in evaluating the consideration, made the parties go back and add a little bit more money to the pot before he was willing to grant preliminary approval.
So, okay, let's stick on the standing issue for a little bit more. So, if you've got similar fact patterns leading to different conclusions from different courts, what is one to conclude from that in terms of any jurisdiction where a case was dismissed because it wasn't standing? Is it just as simple as picking the venue in which you want to file a case, or is there more to it than that? Go ahead.
I think an interesting exercise is actually to tease out the differences in these cases, right? I think Ron is right to mention the Adobe and Neiman Marcus cases because they're so important and interesting for different reasons. And so here's some differences in the fact patterns of those two cases that are relevant. And so in the Neiman Marcus case, right, we have a retail data breach. And what the court said is that there's a couple 100,000 people, I think, who are victims of the data breach. And there was no evidence at that time that their information had actually been exploited by hackers. You contrast that with the Adobe case, and there was evidence that suggested that the hackers had already been posting some of the victims of the data breach's information online, and therefore the court said, well, under these facts, it seems like there might be impending harm for those folks who are implicated, right? So those are two very big differences. I'll also mention this, is that we're talking about standing in terms of whether or not people have been injured just by virtue of the fact that their information has been exposed. And that's an important strand of the argument that we've been fighting for the past 5-6 years. But there's another argument that hasn't been mentioned yet, and that is one about the diminished value of the services rendered by the company who's been hacked. And let me explain what that means. The AvMed decision, which has been extended in a number of other cases, LinkedIn's one, and also in the Adobe case, the theory goes like this. The folks who paid money to buy Adobe services agreed to their privacy policy. In the privacy policy, Adobe promised that they would implement certain types of security measures to safeguard the personal information. The theory that clever plaintiffs' lawyers have been advancing is that because Adobe failed to implement those security precautions, the folks who bought those products should be entitled to some portion of their money back, right? That wasn't expended on the administrative costs associated with data security, protection, safeguarding of consumer data. In the Neiman Marcus case, plaintiffs advanced that same theory. The court said, I think their exact line was, that's creative but unpersuasive. And that's how we can be sometimes. And he said, the court said, the reason why I don't think that's persuasive is this. Someone went to Neiman Marcus and bought a t-shirt, and they walked out in the parking lot and got mugged because Neiman Marcus had failed to spend the right amount of money on security guards in the parking lot. It would be a very difficult case to come back in and sue Neiman Marcus and say, I want a portion of my money back for that t-shirt because you didn't spend the money that you're supposed to on security in the parking lot, right? So that was the analogy that he used. So the conclusion that I'm coming to of these different types of cases is this. In the retail context, it's a harder argument to make on standing that you have some diminished value of the product that you purchased, right? For the reasons that I just articulated, the court said. On the other hand, when you have online goods, software or services or other types of products, it's easier when you can actually point to terms in a consumer-facing contract and say, here's the exact terms, here's what you said you're going to do. You would never provide me with the actual utility that you said you would, therefore I can get some of my money back. And that's a theory that courts have been embracing, and it's something us in the plaintiffs bar are looking at very closely.
Yeah, and I would agree with Chandler. The thing about these cases is they do have compelling facts, and there is something there. And courts are struggling with, well, how much there is there, and how much can you show? And I think even in the retail context, if you put it in front of a different judge, you may well get a different outcome. And so what it's forcing the plaintiff's bar to do is to be more and more creative into looking at the types of injuries that are flowing from a data breach. And then in the meantime, you're also having a judiciary that is becoming more and more educated, just sort of on the natural about data breaches and whether there is harm and what type of harm that is. I mean, things like the Target data breach that got so much publicity helps plaintiffs a lot, I think, in front of courts, because you start having judges begin to understand sort of the technological aspects of this, sort of the more that is involved when a data breach occurs. It was not very long ago that you would talk to a judge and say, well, if a store has your zip code, they can find out all kinds of information by pairing it up with other information they can gather, and a judge would be very surprised to hear that. Today, particularly in California, because of zip code cases, judges are less surprised at that. They now understand that. And so when you have, these are all motions being made on the pleadings, you have plaintiffs that are becoming more sophisticated in making standing arguments. The law has become, because of Clapper, a bit more challenging, but there's still some there, and the judges are I think the trend will be that the judges will, overall, they'll start kind of getting it, and they're going to be treating standing the way standing has traditionally been treated, a minor bump in the road that is pretty easy to handle. I agree, it would be a lot easier, but for Clapper, we wouldn't be still sort of, where we were 3, 4, 5 years ago on the standing issue. But I think, a few years down the road, we won't be talking about standing anymore, because there will be enough cases and that lay out some sort of plan for establishing standing, and the plaintiffs are going to be meeting those burdens.
So just real quick. Yeah. I get a rebuttal, right? So I do think that the venue and the judge are still important. And I think it's interesting. I do a lot of Fair Credit Reporting Act litigation, which involves credit reports and consumer reports. So if I ask people in the audience to raise their hand as to how many people know somebody personally that's had something negative on their credit report, I would expect a pretty good percentage of the people in this audience to raise their hand. If I asked you, how many of you know somebody who has received a breach notice and then has been victimized and been able to trace that victimization to the event, I would expect few, if any, hands in this audience. Other than the two guys on this side, they probably know somebody. But otherwise, I wouldn't expect to see a lot of hands out there. So why do I make that point? One of the things that, it doesn't get a lot of treatment in standing, but it certainly comes up in the damages context, is whether there's been harm. And that harm has a psychological impact on the judge. So if you have a judge who's saying, and judges are busy if you don't know that, and they'll remind you that they're busy. But if you get a judge that's sitting there saying, why am I dealing with this case? So I've experienced data breaches, I know somebody, and I haven't seen any harm, why are we here? I think that will resonate for a while. It will resonate with some judges, not all. It may resonate with the jury if anybody ever is willing to take a case to the jury. Don't take the AIDS case, by the way. Somebody did and lost a bunch. But my point being is that it's still fluid, it's still in transition, and we'll have to wait and see how not only standing law, but damages, and then the mentality continues to evolve.
And just one other note with respect to this diminished value theory that's being put out there. Granted, that is causing a lot of concern stress on behalf of organizations. But as another example, even in the online context, when we're talking about representations and privacy policies in terms of use, often those privacy promises or those statements about what the nature of the security that's being provided are the same regardless of whether the individuals who are subject to those terms are paying for the product or are receiving it for free. And I believe this came up in the LinkedIn context, I'm fairly certain. And so if you're not able to demonstrate that there's really, that the payment is connected in some way to those promises, that regardless of who you are, even if you're just using the LinkedIn free service, you still have those assurances provided to you. I think that's going to continue to create some trouble on the plaintiff's side in connection with the diminished value theory as well. But it is important for those of us who are not only trying to defend these matters, but also to keep clients out of these matters, to keep in mind when we are drafting those terms of use and those privacy policies, not to overreach, not to overstate. It can be very tempting to want to proclaim that you are using state-of-the-art controls in order to prevent these kinds of incidents from happening. But you will probably wind up regretting that if you have an incident, either because you're going to see it in court or because a regulator is going to call you out for it.
Okay. Well, this discourse is entirely too civil, so we'll shake it up a little bit. We'll go off script a little bit. So if we're looking at damages and we're looking at standing, let's go beyond that and we'll talk to the plaintiff's attorneys first. Give me some elements that make for a compelling case. What makes you pick? What are the elements that need to be in place to pick a case? And we'll go back and forth, and then obviously we'll have the opportunity for a rebuttal.
Well, I listened with interest earlier when on the first panel when John Mullen said that a lot of the potential clients that come to him say that they've suffered from some data breach and then they end up just burying it and not disclosing it to the public. And what I can tell you is that plaintiffs' lawyers, our firm is doing this, I know a lot of other firms are too, but we're becoming very diligent in monitoring not just kind of the standard media outlets, but also more underground forums to see where information is popping up. So we even have some automated scripts that we run every week, so we get a report, and if we see that someone's talking about certain personal information being sold or being shared in like underground hacker forums, we'll get an alert. And so sometimes we know even before the New York Times knows that a company has suffered from a data breach. And those types of facts are usually very, very, very hurtful to a company that faces class action data breach litigation, because you can, paint the defendant in this light where not only have they suffered from this data breach and maybe failed to implement certain security measures, but they also decided to bury the event. And we know that because we're the first ones to find out about it before the company even publicly announced it, right? It's something that companies need to be aware of, that we're paying really, really close attention to where this information is coming from and when it is being reported. So that's one. The second one I'll talk about, and it's interesting because in the last conference in Philadelphia, we were discussing the target litigation because it was just getting started. And just recently, in August, a amended complaint was filed. And in the amended complaint, they talked about some of the remediation efforts. And they mentioned that Target had known maybe a month or two before that some of their POS systems were infected with malware and chose to do nothing. I mean, those are the types of facts that you never want to have presented to a court, right? And so I guess maybe the takeaway is to make sure that you have good defense lawyers lined up, so right when a breach happens, you can control the narrative. And also, you want to have all sorts of different measures in place, and there's some folks here I know who are selling these types of solutions, I don't know them by name, but you want to be able to present to the court at least some evidence that you are being diligent in trying to prevent data breaches and that you had a plan in place to mitigate the harm after data breach, and that you're doing everything in your power to make sure that it doesn't happen again as soon as a breach occurred, right? And those types of facts can then at least counterweigh the bad facts that I just discussed a moment ago.
Well, yeah, the takeaway is the cover-up is worse than the crime, right? As always.
But in that system, how are the individuals coming to you? So the individuals that end up retaining you as counsel, I guess, why do they approach you?
we're really good at what we do.
Well, but I mean, I've gotten breach notification letters, and I haven't. I think you're good. I like you. You're a good guy, but I haven't picked up the phone and called you. So why are I'm not being mean. I'm just trying to.
Right. Well, I mean, for the reason why there's so many people in the room, for the reason why politicians talk about data breach issues all the time, why? Because people really care about it. They're concerned about it. Identity theft makes the people afraid. I mean, it's the kind of thing that people are very, very concerned about. And so depending on the nature of the theft, what kind of information was taken, the type of institution that it was taken from, if it's taken from a financial institution, even if it's relatively modest information, that's going to cause more fear than because, my money might be at stake. Like, they may not have taken it, but boy, they got through JP Morgan and they didn't hack my account, but that might happen next time, as opposed to an Neiman Marcus type of thing where they got my credit card information, but that's okay, that's covered. So I think it's those kinds of things. And the reason why, sort of regardless of standing and regardless of the other things, that there is going to continue to be a life to these cases is because the public really cares about this stuff. It's important to people. And they may not exactly know why, they don't know the details of it, but they don't like the fact that their information was provided to a company. The company typically did not take good care of that information, and then it was taken away from the company and out of, presumably responsible people's hands.
And if I could attack Ron for a sec, because it's fun to do that. There's kind of played out theory now, I think, in defense bar. I think they go to the client and say, here's what we're going to do. We're going to find out everything we can about this litigant, because I bet you that Chandler and Tim either paid this person, $100,000 to be part of this class action, or they went to the graveyard.
You can blame Milberg Weiss.
I went to the graveyard and wrote down 5 different names, and those are going to be litigation. That just doesn't happen anymore. I wasn't around. I was like 6 years old when I guess some of that stuff happened. So don't blame me for that. But don't blame me for that. But increasingly finding a client to sue a company that has mishandled their information, and I'll say allegedly mishandled, just to be nice. It's probably the easiest part of our practice these days. There's a data breach. We put up Google AdWords. I'll show you how the sausage is made. We put up Google AdWords and say, did you get a notice from this company? If so, are you upset? If so, contact us. And it's just that easy.
Well, but when you drill down on that, that's the next, and Tim made the point, they're upset, but they don't know why. And there's a reason why they don't know why, because nothing has happened to them.
I dispute all that.
And nothing is likely going to happen to them.
And the challenge is greater because of, if you listen to what we've been talking about, and after Hannaford, and then even Adobe, what the court is saying is you have to find somebody who's actually had some consequence.
Right, and the best thing that a defendant has going for it is the fact that in most situations, most cases, it's very hard to trace the harm to the particular breach. Like, okay, a year and a half later, I'm a victim of identity theft, but I can't say that it's because of that data breach. I can't say where the data thieves got my information from. And that's the best thing that's going for the defendant. The problem with that, though, is that's a known fact. The causative link will never, in most cases, ever be made, but that doesn't eliminate the fundamental problem. And if companies aren't taking care of people's personal data, then there will be consequences for that overall. It could help in certain cases, and certainly it has helped in certain cases, but over time, there's going to be workarounds because it doesn't eliminate the fundamental problem.
But I want to note, there's a recent settlement that's been in the news this week that I think is worth mentioning in this respect, which is Vendini, which is an organization that I believe provides software for ticket sales. And there was an approval for a settlement in a case involving a breach where they're paying $3 million to settle. And what I found most interesting is that this is up in Santa Clara. The judge actually noted, apparently, in his tentative ruling with respect to the approval of the settlement, that the plaintiffs were going to have an uphill battle because, in fact, Vendini, according to the judge, had adopted industry standard security protocols. Nonetheless, they are paying $3 million, of which $1 million are going to the plaintiff's counsel in order to make this situation go away. It was also, at least according to the reports, where the notice went out within a month of the incident. Happened in April of 2013. Notices went out in May 2013. It had industry standard security protocols, and yet they're going to pay $3 million.
So stick on that for a second. Does it make a difference? I mean, there's we already heard this morning, data breaches happen any number of ways, right? And they happen because people lose laptops, and they happen because there's incredibly sophisticated, motivated actors that are thwarting very good systems. So from a plaintiff standpoint, does it make a difference, right? The breach happens. Does it make a difference in terms of how that happens? Does it make a difference whether it's the lost laptop in the back of a cab that has unencrypted data versus very sophisticated actors that break in? They steal the same number of records, but does the methods make a difference in terms of how you bring a case?
No, I mean, I think the lost laptop is, in many ways, the lost laptop with unencrypted data is often a more difficult case than the sophisticated hackers breaking into a system, only because if it's a lost laptop, and this is the SAIC case, you know, the car gets broken into, they steal a couple of cassette tapes and the tapes, and then they go and it's unclear whatever happened, if anything, with the data that was stolen. That's a much more difficult case because it may be that the stuff got thrown in a dumpster and nobody ever saw it, nobody ever did anything to it, and there's no threat of harm. That's a much more difficult case than very sophisticated hackers getting around a sophisticated security system and taking valuable information, presumably to do something with it. You know, I think another sort of variant on that is the hacktivist cases where you have like Anonymous or a group like that takes data to make a different point and not to put it on the black market. You know, what do you do with that case? That's a more difficult case where a plaintiff's lawyer is going to want to look to the surrounding circumstances about how that information was stolen or why it was stolen to bring out the better facts of that case. Because if the stuff, it's the tree falling in the woods with no one around to hear it fall, doesn't make a sound. Those are much harder cases for plaintiffs.
Yeah, and if I can just add a couple comments. We certainly, the first thing we do is look at the method of attack when we're considering whether or not to file one of these lawsuits. I mean, just by way of example, recently at the JP we know that after that attack happened, I think the DOJ or the FBI asked a bunch of other financial institutions to check their logs to see whether or not they've been hit by certain attackers. And they said, yeah, it looks like they tried to breach our perimeter but didn't get in. So then you have to wonder what happened with JP where they had presumably the same attackers using the same methods to get in, but they were successful, whereas the other institutions weren't. And those are good facts for plaintiffs. And I'll also say, in the first panels, they're mentioning SQL injections and cross-site scripting attacks. If you see in the immediate remediation efforts that there was clear text, passwords, or usernames, PCI information that sits right outside the perimeter and that's accessible just using a SQL injection attack, that type of case is a no-brainer to file. It's a much harder case if you look and you find out that a company was breached as a result of some advanced persistent threat from a nation state that took 6 months, and it was a result of some phishing campaign, right? Each case is fact-specific, but I would encourage, if you are the subject of a class action and you have good defense counsel, and you took all the steps that you think were reasonable and necessary to prevent one of these things, tell your defense lawyer, look, let's talk to the plaintiff's counsel and show them what we've done. Show them all this information that we have about the different types of steps we took to prevent this and what we've done in the aftermath, and you might be able to make the class action go away, at least if they're reasonable plaintiff's attorneys.
So I do want to just interject one thing here. And first of all, on class action settlements, at that point you're presenting papers to the court, both sides, to convince the court to approve the settlement. So it's not surprising that the plaintiff at that point is willing to give more in terms of the reasonable procedures used by the defendant, and then we all go and take showers after we're done because we feel dirty. At least I do. But I think it's a good point. It's a question that I'm curious of, is how many times do you go out and hire forensic experts to analyze data and determine causation. So not just cause of the breach, whether procedures were reasonable, but actually going out and hiring experts and in discovery, trying to pinpoint causation.
So we've done that a number of times, mostly in privacy data mishandling cases. We talked about, I think, on the last panel. It's true that most of these cases never reach a discovery because defendants settle. But we certainly would hire a forensic expert, and we have them on retainer. A lot of this work, though, is actually crowdsourced, if you think about it, right? There's usually tons of technologists on the web who look at these different fact patterns, make inferences about what a company should or should not have done, what types of security measures they had in place. And then it's interesting to find that sometimes these technologists who write up these blog posts or reviews, a month or two later you find out that everything that they thought was true is actually right after the forensics teams come in and actually inspect the systems of a company who's been breached. So we obviously don't use that as proof certain that a company's done something wrong, but we can make a lot of informed differences just based on literature that folks on the web are writing and researching about.
So, Tanya, you mentioned before about the response may be more important or most important in terms of keeping these guys from coming calling, perhaps. So what are the right things that a company needs to do if they've had the breach? What are things that can reduce the risk of the litigation?
So you're going to ask me once a breach has happened. See, I want to talk about before a breach has
Go for it.
happened, but we can talk about once a breach has happened as well. So I mean, once a breach has happened, obviously response is critical, and the moving quickly and the being careful about what you're saying publicly and not jumping at opportunities to make public statements, even if you're feeling incredibly awful about what happened. And I think we've seen a number of situations play out where those kind of hasty public responses to these things have not ended well for people. But I actually think that from the mitigation side, the risk mitigation side, and breaches are going to happen. So most of the conferences that we all go to, you've all been told that over and over and over again. I mean, the data breaches are going to happen. It's not if, but when. So when you think about it in that context, this notion that the companies, that when these things happen, someone must have done something wrong and someone must have been harmed as well, it doesn't always necessarily follow. If every single company is ultimately going to be the victim of a breach and can only do its best to mitigate, then it's that risk mitigation piece that's the most important, so that you're staying off the radar of the folks on the end here. So I think lesson number one, of course, listen to your lawyers who are helping you on the compliance side, right? Not just the ones who have to come in to do the damage control in the event of an incident. But there are some, really, from the really sophisticated, meaning making sure that your written information security programs are in place and that you can document all of that for all the reasons you've been hearing already about what's going to come out either in the discovery process or in the settlement discussions. Can you document what you've done to try to prevent these things from happening, and what can you show even if it's not publicly available? Of course, then we start to get into questions about confidentiality and needing for protective orders and trying to make sure that all of your internal documentation about your security procedures isn't going to wind up in the public eye, which you probably don't want, which nobody wants in any situation, but becomes an issue whenever litigation starts to come up. But from those really sophisticated measures in terms of documenting what you're doing on security to the really absurd things, and we haven't talked a lot about some of the non-data breach cases, although it's been mentioned briefly, just the alleged inappropriate use of information, the more and more the cases we're seeing on the marketing side in terms of use of various tracking technologies to gather information on websites and social media, and cases involving the Facebook like button and what that means when it's on your website, and what happens to user information. A lot of organizations don't really know internally even how these things work. So in addition to security issues, right, really basic things like what are your marketing groups doing on your websites? Do you know what the interplay between the various social media sites and your own website is? And what does it mean when somebody is logged into Facebook and they're also using your website? For example, what are the data flows, from collection through use and storage and sharing? Do you really know what's going on within your organization? Where are the links on your website? Really stupid stuff, right? Do you have prominent links on your website where people can find information about your privacy policies? Are you over-promising? Are you under-promising? What are you doing? All of these things are the basic things that can be handled up front. Some of them are what I would probably characterize as minor inconveniences, but that a lot of organizations don't want to deal with on a day-to-day basis because it's annoying to people and they don't really want to deal with it. But the pain associated with those annoyances, because you got to make your passwords longer, or you got to make sure the links are prominent, or whatever it is so much less than the pain when these guys come knocking, that I think that just needs to be communicated even more effectively than it is right now within organizations.
So I agree with Tanya. I think by the time the breach has happened, half of our records already been created, and all of the record for all of our evidence record with respect to whether our clients' processes were reasonable. So has anyone ever been involved in a debate between whether Unix or Microsoft is the better operating system for email delivery? Anybody ever been? And so the types of emails and communications that occur in an IT department, right? So I need every document to be pretty. They just need one, right? So anybody remember Bill Gates when we started talking about electronic discovery and the antitrust case involving Bill Gates? And Bill Gates had, one, probably more than one, but one email in particular that we talked about in the discovery. This is why even Bill Gates doesn't understand e-discovery, right? You remember that? Anybody else remember that? Well, that's one of the things that I don't think companies fully realize today, is that they need to have better governance and controls in place to build us a better record for when we get to the point of litigating whether the processes are reasonable or not. And my sort of, give me 60 seconds on what my soapbox is for right now on governance, is that, and this is critical to, I think, cyber insurance, that decisions are being made about technical controls, administrative controls, and physical controls, and they're being made in the context of a business decision. So I'm deciding as a business unit leader, do I implement a security control which could impede revenue and at cost to my P&L, or do I forego that physical or that security control, get the revenue, and hope that if an event happens, it happens on my successor's watch, not mine? And my point being is there's no financial recognition of that decision in the P&L. Now, Chandler would love if we created a reserve that said, well, we're going to hold back about $100,000 because I didn't implement the security control. That'd be a great exhibit, wouldn't it? What I would suggest instead is that's where insurance comes into play, right? Insurance and the underwriting process. So insurance, and so one retort to the Wall Street Journal article would be cyber insurance actually does play an important role, and one that I don't think has been considered much, and that's in security data governance.
So when we have scenarios of data breach, data compromise, right, most of what we've been talking about so far is more to do with directly data owner having a compromise. Chandler, from a standpoint of when there's scenarios that involve other companies, how are you identifying responsible parties? And is it solely who's collecting the data, or in scenarios where you have a data breach, and perhaps whether it's a cloud scenario where there's other parties that are involved that may be, we'll use the term deeper pockets perhaps than perhaps the data owners? Does that impact the course of litigation in any way?
Yeah, it's definitely a consideration. I mean, I'll use Target as an example, right? I think in the remediation efforts, we've seen that an HVAC vendor might have had a big role in the point of ingress for the hackers, right? And I'm not involved in the Target litigation, but I imagine that the plaintiff's lawyers there are sitting around in a conference room eating sandwiches and saying, should we add the HVAC vendor as a defendant in this lawsuit? When it gets to discovery, I imagine what's going to happen is that they're going to look at the contracts, the vendor contract between Target and whoever the HVAC company is, and see what types of access control language they had in the terms, and then determine whether or not that vendor failed to comply with those terms. And so that would be a major consideration, whether or not to add a vendor. If you're talking about a vendor, a company like Target that has such deep pockets, I don't know if they would actually spend the effort going after it.
Well, what if the scenario was reversed? What if it was, in that scenario, the HVAC was the size of Target and the Target was the size of the HVAC? Does that change the dynamic?
Yeah, absolutely it does. Some of these decisions are...
Right, well, so let's talk about the cloud, right?
Mm-hmm.
So these very large cloud vendors, it could be any of them, I'm not going to pick on any one in particular, but whether we're talking about Microsoft, Google, Amazon, Rackspace, name the company, and a data owner that doesn't have sufficient leverage in the contract negotiations to get the appropriate protections, whether they be security controls, or indemnification, or limits of liability that are carve out from the limits of liability, such that if there is an incident, they have some kind of protection. That's always the scenario in these situations. Almost nobody has sufficient bargaining power to get the protection they need in those contracts. And so, those are questions which, again, as a business matter, companies are having to decide on the fly. Am I comfortable going into the situation knowing that should we have an incident, I'm really, these guys are going to disclaim any responsibility whatsoever. And I think more often than not, the wrong decision is being made in those circumstances because of the business, demands and the drive to the cloud, among other things. And I say that as someone who represents both sides of the picture, both the service providers and the purchasers, but I see this happening again and again. It has more to do with who's the elephant in the room, who's the gorilla, than what really makes sense from a security perspective. And if litigation comes along, forget it. You're just out of luck.
Yeah, and another explanation of how this might play out too is that you might end up suing one defendant. You get into discovery, realize that they did have these contracts in place with the vendor. The contract specifies that they have to use this type of data protection to safeguard their customers' information. And they also went and they made sure that the vendor was complying with those terms, and they're doing everything in their power to make sure that the vendors safely handle that information. And it turns out that they were negligent and didn't do it. Then the new defendant might become the vendor, and the first defendant might drop off. I can envision a circumstance when that would happen when you have a huge, company that's tasked with safeguarding a large amount of information.
Right. And one last thing. If you think that Microsoft or Google or Amazon or Rackspace is going to let you come onto their premises and look at their controls, you're crazy.
You could do something else besides that. That's one example you could do.
That is one of them.
But from a plaintiff's perspective, ideally you have one large solvent defendant that would be the defendant in the lawsuit because it's simpler. It's simpler for class certification reasons. It's simpler for liability reasons. So that's the case that tries to get built, and then it's really almost more tactical decisions where you might be naming somebody else who is also liable because of solvency issues, insurance policies, some other defendant that might be a deeper pocket, potentially maybe discovery issues if it's easier to name that person to get this, and you need a lot of discovery from that party, then you may not want to name that entity as a defendant as opposed to trying to get discovery through subpoenas and things like that.
Let me just address quickly Tanya's point too. And it's not necessarily you have to go on site and inspect the systems of the company that's tasked with controlling your data. Even something as simple as having an administrator there certify that they've implemented the security controls that were specified in your contract. At least that's some sort of a record. So if you get sued by Tim, he can look at that and say, oh, well, geez, they did everything they could have done.
Right. No, as an evidentiary matter, that's right. So while some of us may know that the true value of the piece of paper that has the checkbox on it may be negligible, it will nonetheless help you in court. So yes, get the piece of paper.
All right, so now we've got both sides involved. We've got a messy case. We've got lots and lots of money at stake. Entrenched positions on both sides. How do we reach a settlement in these cases? What are we looking for?
Well, settlement in these cases in particular, for a number of reasons that are beyond this litigation is still sort of the wild, wild frontier. From a plaintiff's perspective, when you file these cases, nobody really knows where these cases are going to go, right? Which, the plaintiffs are always much more comfortable in that sort of environment than the defendants are. What's our exposure? In a lot of these cases, the defendant, the defense lawyer can't really state what the exposure is in a typical data breach case. So that provides a lot of opportunity to settle the case, because if the trend really is towards keeping these cases around, and then once we actually get into discovery in some of these cases and where the remedies go, the remedies could be absolutely enormous. Take any of these large recent data breach cases. If Target were to pay out $25 either in cash or it costs $25 per class member, that's $1 billion settlement, right? Or $1 billion in liability. And you can certainly imagine scenarios where, if the case goes to trial, the exposure could be far greater than that. How much more? Nobody really knows, because that's part of the developing area of the cases of, what is the measure or measures of damage, and how do you get there? And nobody really knows what all that means. So there are tremendous opportunities to try to figure out what types of settlements are. Meanwhile, you have, for good reasons, you have courts taking much closer looks at class action settlements. And we are in the throes of this right now, beyond just data breach cases, but in the class action arena generally. So courts are really taking a hard look at what types of settlements there are. So a settlement where the defendant comes in and says, okay, we're going to get this done quickly, and we're going to get it done so it doesn't cost us anything, and we are so clever that we're going to be able to figure out a way that's going to end up actually making us money, because, I don't know, we're going to give, coupons on products that we make a profit on, greater than the amount of the coupon anyway, and this is going to be great. It's that type of settlement that ends up really hurting the defendant in the long run if the judge says, no, I'm not going to approve that settlement. And it's happening so much more frequently, where even at the district court level, the judge is saying, no, I'm not going to approve that settlement, go back. None of the parties want to be in the position of having to go back to the settlement table. But from a defendant's standpoint, there's only one way that settlement goes. It goes up. It doesn't go down when the judge sends the case back. So creative solutions that actually address the problem and compensate people in some meaningful way that actually reaches people is the challenge. And then you have to do it in the context of these really large data breach cases, or with a company that is much smaller and doesn't have sufficient insurance coverage in a way that is actually going to be affordable to the company. Because you're not going to be able to get past a settlement where you say, gosh, every class member is only getting 5 cents, but we don't have any money. That's not going to fly. It's got to be some sort of creative solution to it. The other thing that I think happens, in these cases that are settling earlier rather than later, a lot of you in the room can tell me why better than I can, but it is this sense of uncertainty in the possible exposure that really drives this. If you take a look at the zip code cases, so zip code cases are in California and a couple other states that prevent the collection of zip codes at the time people pay with their credit cards in a retail transaction. Not supposed to collect and record the zip code. And these are statutory violations. A number of zip code cases were brought, and a lot of them settled early on. There are a few companies that continue to fight them, and Restoration Hardware is one where they took it to trial. They could have settled that, I wasn't involved in the case, but I'm sure they could have settled that for a song and probably some coupons in state court, and they got hit with a $36 million judgment. Why? I don't know. The penalties are mandatory once there's a finding of liability. Liability is like that. It's the easiest part of the case. And the penalties are from anything north of $0 to $1,000 per violation. That adds up very, very quickly. They were lucky that it was only $36 million because the judge said, well, I can go up to $1,000, but I'm going to find that each violation is worth only $30. Well, you start figuring the number of violations in the statutory violation case, and it adds up very, very quickly. So why, and there's still some zip code cases that are out there that are heading towards trial. I don't get why, because liability is clear and the exposure is great, and yet they're still sort of rolling the dice.
There's a lot of reasons why, but in settlement, I think, has anybody heard of the Class Action Fairness Act? Right? So the coupon settlements became much more difficult after that was passed, and I think judges were much more attuned to coupon settlements. And then, has anybody heard for the Center for Class Action Fairness? Have they shown up in any of your settlements?
Not in mine, but I know.
So they're showing up in some of mine that are more creative. And so it's things like we were using before, like Cypre. So if you look at the Google settlement, for example, where there was something like 70 million class members, and Google ended up agreeing to settle for 20 million with, I think, most of that, or half of that going to Cypre. Cypre is basically, I'm not going to give any of the class members money, I'm going to give money to an institution that presumably is going to benefit all the class members because of what they do for society. So for example, the Identity Theft Resource Center is one that we used for a long time in Cypre settlements, because they're going to go out and help people who are victims of identity theft. Well, the courts are striking down those types of settlements. You have the Bluetooth settlement as well, that the Center for Class Action and Fairness came in and was able to undo on a Cypre issue. And what does all that mean? All that means is that we have to find a way to structure a settlement that's going to deal with the realities of these cases. So one, and you mentioned them both. So one is the size, how many people, and the other is how do you value the harm. And I think that's the struggle that we're still going through, especially when you have to work within the structures that Rule 23 provides to us. Right? So it's B2 or B3. Everybody knows that you don't settle unless you get full relief. Right? You want a full release. But to get a full release, you may have to pay money. And for 70 million people or 100 million people, I settle the class of everybody in this room. So it's every adult over the age of 18. How do you pay out any money in that? You can't. But you have to be creative in trying to find solutions. The only other thing is on, the zip code cases, the statutory damages claims provide a particular incentive for plaintiff. We haven't talked about those. But they also present challenges for why you don't go forward in litigation. Because it's essentially, if you're found to be liable, you're writing a check for $100, $1,000, or $2,500, depending on the statute that's at issue. So I think that's in part why, in those cases, companies are settling.
And I think one thing that happens with settlements that turn out to be bad, the dynamic often is that the defendant, the defendant is trying to get the best deal for itself. Naturally, makes sense, right? And the defendant will often push a little too hard, maybe not be as forthcoming with information that maybe was never asked for by the plaintiff's lawyer, something like that. And so they structure a deal that just doesn't smell quite right, or the plaintiff's lawyer hasn't kicked the tires enough, or a mediator was really convincing and convinced the plaintiff's lawyer to go with it and everything would be fine. Particularly in today's environment, getting a good settlement is much more of a collaborative act than it has ever been before, because the defendant is not getting away with something. Potentially maybe, but increasingly, defendants are not getting away with things. Cypre is a great example. A traditional use of Cypre is an excellent tool to settle cases where the damages per person are very small, but the transactional cost of getting the money into the pockets of the people, so you don't have their addresses, the damages are fairly worth, $5, but it would cost more than that per person to get money to a large number of those people, okay? That kind of situation. If you build the correct record and you're fair in assessing it, then a Cypre settlement is perfectly justified by the case law. But the problem that we see sort of over and over again when these settlements are presented to the courts is that either they're not really a good candidate for a Cypre settlement, or the record is not adequately developed and submitted to the court to justify that kind of settlement. And with these kinds of cases in particular, where you have potentially huge exposure, and far greater than what the company can afford, I think collectively plaintiffs and defendants are often not doing as good a job at either making sure that that settlement really makes sense or documenting it for the court when the time comes. And then you will get objections, and then you have to decide what to do with them, and sometimes just fight them. And there's plenty of appellate decisions also where the objectors have lost, and then that area of law has been clarified, and we're all able to move on from there.
So we've got about 5 minutes left. So going back to where we started, right, which was standing, we're all going to probably all be here a year from now. We're all going to be in this room, and maybe we're all going to be on the same panel having the same debate. So who wants to look into the crystal ball and tell me whether or not we're going to be actually having the exact same debate, and then standing will be dependent on the court and so forth?
Well, one thing I want to mention in that context with standing, and I'm going to let, I may let others talk about some of the law that's pending before the Supreme Court right now, but so many of these cases are these statutory damage cases. We mentioned the Song Beverly point of sale, zip code, and other personal information collection, but there's a lot more. The TCPA cases involving the federal legislation that doesn't allow you to do the automated text messaging without consent, or the auto dialing marketing. There's tons of litigation being filed under the TCPA, which falls into the privacy bucket as well. And those are cases where you have the same dilemmas as far as the settlement issues are concerned, and where the standing issues really don't present themselves in the same way most of the time. That's not an issue. In fact, classes are getting certified. I've seen a lot of cases, classes getting certified in those cases pretty easily without a whole lot of effort on the plaintiff's part. And so, frankly, I think the future of privacy and data security litigation, to the extent that the cases involving the data breaches or other situations where you got to be able to demonstrate injury, to forget about standing. Even when we get past standing, you're not going to maybe get much further because you're not going to be able to show injury beyond that, summary judgment or whatever. The future of privacy security litigation is in these statutory damage cases, and it's a real problem for those of us on the defense side who are seeing clients get tripped up due to really sometimes very minor mistakes that really shouldn't result in this kind of liability or potential liability. And so my personal belief is next year and in years to come, we're going to be talking much more about those cases than we are anything else.
People love the guy who says very little right before lunch, so I'll just add that. If you follow the trend lines, I think we'll probably see double the amount of data breach litigation as we have this year, because plaintiffs' lawyers are starting to see that these are financially liable cases. And the second thing I'll say is that I think that courts are going to continue to follow the trends of embracing some of these standing theories. So I think next year we'll just say, look at these 10 more cases where standing has been found. And also, tons more state court cases. I think you'll see smaller, mid-sized state court cases.
Right. And also, the more restrictive Article 3 standing requirements are, the more cases they will get kicked out of federal court, but maybe perfectly viable cases in state courts. So you could actually end up with very large cases in various state courts.
So we've left all of about 30 seconds for our Q&A, but are there any questions out there? All right, well with that. Let's make use of that 30 seconds, Ron. Let's go.
So the one thing that hasn't been touched on is the Internet of Things. We were talking about this, so it's interesting to me that Ford's coming out with a car that's going to have wireless included in the car. So just think of the possibilities as a plaintiff lawyer, wireless in a car and Ford. So it's not just the HVAC, so that'll be interesting. I also think that eventually we'll see the state of the legislators become more involved, and as Tanya mentioned, there's an opinion out there on the FCRA called Spokio, and if you're interested in it, you can come and talk to me afterwards, because I'm out of time.
So, thank you very much.